Litigation is the entire process from when you first file a lawsuit until it's either settled or resolved through a trial. A case gets put into litigation when an insurance company undervalues or doesn't offer enough money to settle a case. What happens at that point is my litigation department will get the file, we will reevaluate the entire case from beginning to end, what's happened up to that point, and we will determine the best course of action for actually filing a lawsuit. We'll develop what we call a litigation plan. And a litigation plan means what are we going to do from the very beginning of the case until the case ultimately gets tried in a court. When I review a case for litigation, I'm looking for several things. I'm looking for the type of injury that the person sustained, type of accident that happened, and I'm also looking for what the goal is in the litigation. Why the insurance company has either denied responsibility for the accident or why they've offered an insufficient amount.
From a negligence theory of liability, there's 4 things that need to be proven. One is that the defendant owed a duty to the plaintiff. Number 2, that that duty was breached. Number 3, there's approximate causation from the damages, which is the 4th element that is related to the breach of the duty. And once all those 4 things are complete, you have legally satisfied your requirement to prove that the defendant is responsible in this case.
One of the things you want your lawyer to do is to look at the case from the defense's side so that we can anticipate and be ready for anything that's coming at us. Discovery is the part of the lawsuit where both sides exchange information.
The plaintiff and the defendant get to propound discovery on each other and find out all the facts that are going to be presented later on at the time of trial.
There are many devices that are used during the course of discovery. The deposition was an oral question and answer session where the attorney will ask questions under oath in front of a court reporter, and that will be transcribed and written up into a booklet form. Mediation is a settlement conference. Essentially, both sides will come to a meeting room and a mediator will act as a neutral third party. They don't make a decision. They're not a judge, they're not a jury. Essentially, they sit there, they listen to both sides, and they try and help facilitate a settlement. They'll bring offers to either side, they'll bring counter-offers. They will also play the devil's advocate sometimes. They'll tell you why they think maybe your case isn't as strong as you might think it is, and they'll do the same thing to the other side. It's a very good opportunity to try and resolve a case without having to undergo the expense and the rigor and the time of a trial. And the good thing about mediation, if it does settle, is it's done that day. Case can be over that afternoon.
We begin a dialogue whereby they try and discuss the issues that they see in the case, and we go back and forth arguing any legal issues that may apply to theories of liability, any argument that may be applied as to whether or not injuries are related to this particular incident that they would be evaluating, and try and come to an amicable settlement.
Once a case does get settled, the insurance company will typically send 2 things over to the firm. One will be a release, and a release is basically a contract where you say, in exchange for the amount of money that they're offering to pay, you agree to release their insured, the person you're suing, from any further responsibility for the case. The second thing that they send over is the check. Winning is always great. I mean, no one's going to tell you either side you win, you feel good about yourself. But, you know, I think winning on the plaintiff side feels even better because you've helped someone. You know, I've had clients that we've won their case and they've hugged me, they've cried, because the torment and the stress of going through a lawsuit is really only felt by the victim, the plaintiff. The defense is an insurance company. If they lose the case, they go on to the next day. If a plaintiff loses a case, it can be devastating financially and emotionally. So we really have a lot more pressure on our side, and so settlement is always a good thing if it can settle for the right dollar figure, and if you have to ultimately go to court and we win, then it's always a great thing.